5 weeks later, on August.
Welcome back to another jaw-dropping courtroom breakdown. Today we're diving into the case of Christopher Harris, a man facing not one, but two major charges: aggravated assault and aggravated robbery, while already out on a massive bond. The judge lays out a devastating timeline, exposing not only Harris's repeated violence, but also how his own mother lost tens of thousands trying to keep him free. Stick around, because this one spirals from shocking testimony to a dramatic ruling where the judge doesn't hold back. Would you risk $50,000 to post bond for your child if you knew the danger? Let's find out.
It's an announcement.
Yeah. Oh, that's the other document. Oh,
He's in custody. Where's Christopher
they
Harris?
filed a motion to increase the bond.
Christopher, he's in custody? He's in custody.
In the other case.
Okay, hold on. So if he's in custody, why did y'all file a motion to increase the bond?
He already posted a bond of 250,000, and then he got out.
Here's where the legal confusion starts. Harris already posted a $250,000 bond, meaning his mom had to come up with about $25,000 cash. But when he reoffended, the state pushed for an increase to $500,000. Remember, bond isn't just about money. It's a guarantee that the defendant will stay out of trouble while awaiting trial. But Harris didn't hold up his end. Question for you. If someone already violates bond once, should judges even allow them another chance? Or is revocation the only fair option?
$150,000? Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
My mom was SLAMS.
It's five, so she posted 50,000. Okay, there's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all? That's, I can see you don't seem real upset about it. It would be for me.
The $250,000 bond is still good. He was arrested while he was out on bond for a new aggravated robbery. So this $250,000 bond is.
That hasn't been
still
revoked yet. That hasn't been revoked.
Correct.
Okay. In 25 CR 1020, Christopher Harris is present with his attorney,
Oh, let's see that.
Mr. Adams, and the state.
Pay attention here, because the judge is laying out a brutal timeline. In July, Harris was charged with aggravated assault after allegedly firing 6 shots into a victim. He posts bond, walks free, and within just 5 weeks, he's accused of aggravated robbery, this time involving multiple suspects, stolen jewelry, and even a stolen Lincoln Navigator. This escalation is crucial. Judges always look at whether a defendant learns their lesson after bail. Clearly, Harris didn't. What would you do if you were the judge? Raise the bond sky high or cut him off completely?
Afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right?
That's correct.
Okay. And August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the
Yeah.
50?
The new one, the 500,000.
The 500 was set by Judge Jerome.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting. And the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled, and so a $250,000 bond was set in that case. So, just a few weeks later, and it looks like we're talking about.
And here's the bombshell. Harris wasn't just there. He was allegedly wearing an ankle monitor at the time of the robbery. Imagine that. You're literally being tracked by GPS, and you still commit another violent crime. The judge even points this out. Who does that? And if that's not enough, police found Instagram videos of Harris flaunting the stolen jewelry. It's reckless. It's bold, and honestly, it's almost self-sabotage. Do you think ankle monitors actually deter crime, or do they just help police clean up the mess afterward?
And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont, with the lights on and the engine running. And observed someone named Arthur Gouldsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You know, 3 people at gunpoint and then steal everything, tell them to run and then shoot at us. Yeah, Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle. The defendant had an ankle monitor because of his last event, so he wasn't hard to find. And they were able to track his movements and put him in the vehicle at the time of the robbery at the robbery location. Who does that? You know, when you got an ankle monitor and you're going to be tracked, why would you be around some place that causes trouble? And they put him right at the location at the time of the robbery. And so, if that's not enough, an Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry that was stolen from the robbery. Okay, there is a motion to.
Now the legal arguments collide. The defense is saying, Judge, $500,000 is already double what he paid before. Why not just keep it there? Meanwhile, the state pushes back, arguing that Harris's repeat violence proves no amount of money. will keep him from reoffending. This is a classic legal clash. The defense focuses on fairness and proportionality, while the prosecution zeroes in on public safety. Here's the real question. Should bond exist for defendants who repeatedly commit violent crimes, or should the court have the power to shut it down immediately?
And double to the 500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled, and that's something that he has not made, and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything, statements?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into bro?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That wouldn't be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness, remain in Jefferson County, and 2 test spots.
Just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, and then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So
This is the turning point. The judge says flat out, the bond system didn't work. Harris's ankle monitor, high-dollar bond, and court restrictions all failed to stop him from committing another violent robbery. And here's the kicker. The judge revokes all bonds, setting his status to no bond. Translation? Harris is staying in jail until trial, no exceptions. And the most heartbreaking part? His mother loses her $50,000 bond money permanently. Do you think she's also a victim here? Or does responsibility ultimately fall only on Harris?
need, and for the protection of the people, and to see that the Constitution works, so that we can live in peace, the defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies. So, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000 bond that was paid originally. That is revoked. That is lost to the, unfortunately, to his mother who posted that bond, but that's the way the rules are. Ironically, you don't seem you don't seem too upset.
So, to wrap this case up, Christopher Harris went from a $250,000 bond for aggravated assault to committing another violent robbery while wearing a GPS tracker. The judge decided enough is enough, revoking his bond entirely and keeping him in custody until trial. This ruling highlights the delicate balance courts face, protecting the community versus giving defendants second chances. In Harris's case, the court drew a hard line. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.